Do you intend to self-petition for VAWA immigration status? If so, good news. USCIS adopted 3 major policy adjustments to make this legal remedy more accessible to you. Hi, my name is Andre Major, immigration attorney and an immigrant myself. In today's episode, I will discuss 3 major policy changes that US made for VAWA self-petitioners. Before I begin, please click the subscribe button below and hit the notification bell so that you get all our regular updates on immigration content. Please leave us a comment below about your thoughts about today's topic and check out our other videos. Let's get to it. Over time, the United States government has intensified its efforts to safeguard victims of abuse by refining existing regulations and restructure them to make them more accessible to victims. On February 10th, 2022, that's this year, USCIS issued various VAWA self-petition policy revisions that would significantly influence victims' access to VAWA remedy. Fortunately, this has expanded self-petitioning for VAWA immigration status. If you want to self-petition for VAWA immigration status, it's vital that you know about these changes made by USCIS. Before we get there, let's define what is VAWA. VAWA, also known as the Violence Against Women Act of 1994, was enacted to allow non-U.S. citizens or immigrants who are victims of abuse or battery to file for lawful status without the abuser's assistance. The legislation allows victims to be self-sufficient and escape their grave circumstances by offering them a work permit, the right to certain federal and state public benefits, and the opportunity to get a green card. Now, what are the 3 modifications USCIS made on VAWA self-petitions? First, policy change number 1. Divorce does not preclude a stepchild or step-parent from being eligible for VAWA self-petition. In the case of Arguijo versus USCIS, Arguijo versus USCIS, the U.S. Court of Appeals for the 7th Circuit ruled that a divorce does not terminate the relationship between a step-parent and a stepchild. Thus, they are still eligible for a VAWA self-petition. This means that if a parent-step-parent marriage ends in divorce, a stepchild or a step-parent remains eligible for the VAWA self-petition as long as they meet the other eligibility requirements. For example, stepchild must not have reached 18 years old at the time of the parent's marriage, which created the stepchild relationship. So if they married after the child turned 18, no stepchild relationship was created at all. However, if there was one, and then there is divorce, the divorce does not terminate that relationship. Policy change number 2, providing a connection between the abuse suffered and criminal conviction, if any, can help establish good moral character requirements. One of the primary requirements for a VAWA petition is that the petitioner is of good moral character. This means that you can be barred if you are convicted of any crime within a 3-year period before filing your VAWA petition. However, an exemption may apply if you can prove that the criminal conviction is connected to the battery or abuse that you suffer. Before, this would only apply if the petitioner was compelled or coerced to commit the act of crime. However, with this change, establishing the conviction as a causal or logical relationship to the battery abuse can help the petitioner qualify for the exemption. Policy change number 3. Proving the shared residency requirement has been expanded to consider more situations. Among the requirements for VAWA applications is proving that you shared a residence for a home during the marriage with your spouse or during the qualifying relationship, such as a parent-child relationship. Now, USCIS updated its interpretation to also consider the case if you lived with the abuser at any time in the past, even before your marriage. This means self-petitioner is not required to have lived with the abuser during the marriage. You could have lived with the abuser before the marriage, and I have had cases just like that. Moreover, USCIS also gave more consideration by not requiring that the shared residency occurred within the United States. Only this allowed previously shared residence that happened outside the country to also be considered. For example, if you and your spouse lived together in another country before getting married, but were not able to live together after your marriage for whatever reason, you would still be allowed to file for a VAWA self-petition. And folks, that wraps up the 3 primary policy changes that affect the scope and requirements for VAWA self-petitions. Call us today to schedule a free consultation for expert legal advice if you need more information on your case or if you need any help in your immigration journey. If you find this video informative, then please like and share it with your friends who are also applying or thinking of considering applying for a VAWA green card. If you have any ideas of future videos or would like me to talk about a particular immigration-related topic, go ahead and let me know in the comment section below. Until next time, stay healthy and be safe.